You shut down Google if you need to shut down Google.
On January 25, 2022, Mike returned to Rockingham County Courthouse to attend Day 2 of the proceedings. If you missed it, be sure to jump back to Part 11 or earlier to get all caught up on what led up to this day. Remember how Prosecutor Cockman sent an email on January 19th with a motion to continue to Mike in the court? An image of the motion appears on the screen. Excerpts are as follows. In support of this motion, the state states the following: that pursuant to the most recent COVID-19 guidelines, as set out through the North Carolina Administrative Office of the Courts, the assigned Assistant District Attorney, Matthew W. Cockman, was required to go into quarantine during the entire week of January 10, 2022, due to a potential exposure. The assigned Assistant District Attorney subsequently tested positive for COVID-19 on January 17, 2022, and is currently under quarantine for a minimum of 5 additional days. So Cockman had tested as COVID positive and still needed to quarantine according to the county health guidelines. However, Judge Albright ordered all parties be physically present in court for Monday, January 24, 2022, despite Mike's previous messages and accessibility requests, informing the judge that he cannot tolerate a mask for medical reasons. An image of an email appears on the screen. From the court clerk, Barbara Rebb, relaying a message from Judge Albright. Good morning. Judge Albright will conduct a hearing on Mr. Cockman's motion to continue in the case of State of North Carolina versus Michael Paul Nelson. Mr. Cockman and Mr. Nelson are expected to be present for this hearing in Courtroom A at 10 a.m. on Monday, January 24, 2022. Thank you. So, the judge wants to conduct a hearing and is requiring all parties to be physically present to determine whether or not he should not require them to be physically present and just continue the case due to COVID exposure risks. Just for good measure, and to show even more evidence that the judge, like many others in these governmental positions, have no intention of actually following the rules they enforce upon us peons, let's check out the county COVID protocols that were in place at that time. An image of the county's website appears on the screen. If you test positive for COVID-19, isolate. Stay home for 5 days. If you have no symptoms after 5 days, you can leave your house. I guess if the judge can just ignore the Constitution and the ADA county protocols that were being enforced like laws in some places, present no concern whatsoever, especially when he is wrapped tightly in his magical cloak of judicial immunity. In court on January 24, 2022, Mr. Cockman was still symptomatic, as can be heard in his voice on the record when he spoke. He can also be heard coughing numerous times on the record. To make matters even more dangerous, Judge Albright ordered Mr. Cockman to go into a room with Mike and his auxiliary aide to review 3 hours of videos, without a visual interpreter. Please refer to Part 11 for that audio. Check the description for the link. After a long day at the courthouse, Mike's auxiliary aide, Mr. Simmons, finally got home late that night. After Mr. Simmons arrived home, he took a COVID test that came back positive. It is highly likely Mr. Simmons contracted the contagion while he and Mike were at the courthouse in close proximity to Mr. Cockman. Mike made alternate travel arrangements to get to court the following morning. Even without his auxiliary aide, Mike headed out, acting in good faith, to attend the hearing and fearing arrest, or worse, if he did not. Once he arrived, the security asked the then customary questions to determine Mike's COVID status. Just to be clear here, regardless of Mr. Simmons' COVID status, due to Judge Albright requiring Mike to be exposed to the COVID positive and symptomatic Mr. Cockman, the previous day, Mike would not have been allowed in the courthouse, as his answer to whether or not he had been exposed to anyone with COVID-19 would have had to be yes. Wouldn't that mean that everyone in that courtroom should have answered in the affirmative as well? Yet only Mike was blocked from entry and kept outside in the sub-40-degree temperature with snow on the ground. While he waited outside at 8:58 a.m., Mike emailed Barbara Rebb and Cockman the picture of Mr. Simmons' positive result and informed them both of his current status. Standing outside the courthouse, in the cold, in January. Remember what happened last time they wouldn't let Mike inside for court at this same location?
You're not so you're physically not letting me. For what? Okay. Deputies are preventing me from appearing. So I'm still here intending to appear before the court. So I've been denied access. I'm here to do the business of the court, acting in good faith. So if you want to arrest me because I'm at court, then that's on you. But I'm here to do the business of the court. I'm here to go to court.
Okay. You want to know if going in naked is an option? Can he go in naked as an option?
Watch the Nazis.
Can he go in as man?
Breaking the oath and breaking the Constitution. The first oath they took is to protect our Constitution.
One of the biggest lawsuits y'all getting ready to have, guys.
All these people
Are you stripping him of all of it? But that's okay for carry? Like an old-fashioned blind man?
Wow. After not hearing a response for many minutes, and after not hearing people entering the courthouse for several minutes, Mike opened the courthouse doors to ask the security if he was relaying Mike's status to the court. The guard informed Mike he was and told Mike to stand by outside. Mike did not dress to stand outside in sub-40-degree temperatures for hours. He dressed the same as he did on Monday, expecting to go into the courthouse for court. At nearly 11 a.m., Deputy Gibbs informed Mike that Barbara Rebb hadn't received the email with the information he had sent at 8:58 a.m., so he sent it again at 10:48 a.m. to ensure the court was informed of the situation. Mike remained symptom-free that morning as he stood on the steps of the courthouse. But the Rockingham County COVID protocol says to quarantine since he was exposed to Mr. Cockman and subsequently Mr. Simmons. Deputies Gibbs and Bullens, both who had been a part of kidnapping Mike last time he was denied entry, came outside shortly after 11 a.m. and relayed a message from Judge Albright. Gibbs relayed that Judge Albright said Mike wasn't cooperating with the court by not taking a COVID test and not disclosing his vaccine status. Mike simply did not consent to non-medical personnel administering a medical procedure that he did not wish to undertake and invoked his right to body autonomy. He also did not want to disclose his vaccine status as it is personal medical information that only the medical personnel responsible for his health care are entitled to. Mike invoked his right to medical privacy. It sounds like Judge Albright was declaring that invoking rights is the same as not cooperating with the court, and that the only way to cooperate with the court is to waive rights. The previous day, in open court, Judge Albright made a finding of fact on the record that since Mike was pro se and invoked and refused to waive his rights to the assistance of counsel, that he forfeit those rights. So on day one, the judge declared that invoking and not waiving rights meant forfeiting those same rights, and on day two, invoking rights meant not cooperating with the court. Mr. Simmons indicated to Deputies Gibbs and Bullens on speakerphone that he was well enough to assist Mike remotely via WebEx from his home in quarantine. He had, in fact, already assisted Mike with 4 WebEx hearings in pre-trial matters in North Carolina Superior Court up to that point. Mike and Mr. Simmons asked the deputies to relay the request to Judge Albright to conduct court via WebEx so all could be in compliance with the COVID protocols and court could proceed. After standing in the nearly freezing temperatures for over 2 hours, Mike was informed by Captain Bullens that Albright had finally ordered that court be continued. In that order to continue, Albright tucked in orders regarding Mike's administrative ADA requests and what was and was not permitted, so Mike began the process of appealing the clearly discriminative denials. Stick around for more videos outlining Mike's appeals all the way up to the Supreme Court of the United States. Will anyone step in and correct the huge equal access ADA violations, or will they turn a blind eye to the corruption in the lower courts? As of the creation of this video in September of 2024, 2 years after the proceedings discussed and 4.5 years after the initial charge, the NC courts are still pursuing this clearly frivolous charge against Mike. It is more clear than ever that this whole process has been to punish him for simply standing up for the rights that he swore an oath to uphold and protect. Thanks for watching. De Oppresso Liber.